Is this Spotify?
Hey everyone, welcome to Morning Tea with me, Tracy V. Allen. And today I have my guest, Eilene Brown. Yes, awesome. Eilene Brown.
Eilene.
She is a lawyer. She is a estate planner. So she does wills and trust. And I know in our community that is lacking, because we see all of the GoFundMe accounts that are set up when people pass away, and things are left in chaos or left up to the state to figure out for you. We don't want that to happen. And I think right now, with the pandemic happening and so many people in our community just passing on, it's leaving a lot of chaos. The way to build wealth is to plan, right? Because
exactly.
the title says you can't take it with you. And we've heard that all our lives. You better spend your money because you can't take it with you. Well, you don't want to spend all of your money either, because you have children. Your children are going to have children. Their children are going to have children. So if you ever ask yourself, how does the rich get rich and stay rich? It's because they do estate planning. Right? So today, that's what Eilene is going to be talking to us about. So I'm going to tell you to grab your pens and paper and take notes. You're going to need to get in contact with Eilene after this so that you can set up something. It's way cheaper than you actually think it is. Like, you may think that it's going to be this ginormous amount of money, but you don't know until you talk to someone about it. Okay? So I want you to share, ask your questions about this, and share with everyone that you know, because estate planning is pivotal to your survival and the success and the legacy that you want to build for your family. And trust me, I've had enough conversations with Eilene that that's why I can just keep talking myself. But I'm going to stop talking now. And Eilene, introduce yourself to the audience.
Hi, everyone. My name is Eilene Brown, and I am an estate. It's okay, Tracy. I'm an estate planning attorney here located in Maryland. I'm also barred in DC and originally from New York City, Brooklyn, New York.
Nice. There's a lot going on in Brooklyn right now.
Yeah,
a lot. It's sad. So we're talking about estate planning, and we want to start with, tell us what estate planning is exactly.
Okay, a lot of people get confused by that. An estate plan technically consists of 3 documents. Okay. You want to have a last will and testament. Mm-hmm. You want to have a power of attorney and an advanced medical directive. And the advanced medical directive takes care of appointing someone to make medical decisions on your behalf should you become incapacitated. The power of attorney is for financial reasons. If you become incapacitated, someone can take over for you financially. And I like to call that the document that's really for when you're living. So you can still have a quality of life, the same quality of life that you had before you were incapacitated. You can continue in that same standard and quality of life if you have a power of attorney, versus if you don't, you have to go with guardianship. And then the last will and testament is the typical document that most people think of, which is the document where you can state what you want to happen with your assets when you pass away.
Okay. So let's talk about the power of attorney, because I myself have some misgivings, I guess, about it, because I've seen where people have abused their power of attorney. How do you create a power of attorney where someone does not end up abusing it and probably stealing from you? Like, is there a way to do that? Because I think that's one of the reasons why a lot of people don't have one. Like, I've had one. If I've had to go into surgery, I know I need someone to take care of the bills and be able to go to the bank and make deposits and withdrawals or whatever, but it's a limited power of attorney. So as soon as I'm back, the power of attorney ends. So tell us about how you can have one that is for the longevity of your life in case anything ever happens, not because something is going to happen.
Right. And you make a great point. You mentioned that you had one when you went into the hospital. So that's a really good point, that the power of attorney is for when you're incapacitated. Mm-hmm. And if you're no longer incapacitated, then it should not be in effect. Now, it could be for permanent incapacity or temporary, like yours probably was with the hospitalization. What you want to do, and with all of these documents, you want to plan in advance. That's why it's called estate planning. You don't want to do these documents at the last minute. And I'm not saying you did, I'm just giving the example. You don't want to do it at the last minute, and you don't want to do it in a rushed or emergency situation. You want to do these documents when you can think about it, when you can talk to your attorney or talk to a friend or talk to a family member and really make a good decision. No different than if you were making another huge life decision, buying your first house or, something like that from a financial perspective. And when you do it that way, you're going to select someone that you really trust, because these documents are putting a fiduciary in place. And fiduciary means someone that is in a trusted capacity. So I'm going to come back to the fiduciary if there's an issue with the fiduciary. But as far as the power of attorney is concerned, you want to sit and think about, and I love to say this to people, think about who you would give your wallet to right now. If you had to give your money, your wallet, your bank cards, every bank card you have to someone right now to take care of it for you right now while you're competent, healthy, no issues, no concerns, who would you give your wallet to?
Yeah.
If you can't think of a person, then you don't want to put them on your power of attorney. But if somebody comes to mind right away, that's who you want to put on your power of attorney. And then when it comes to the trust, that's a great way to think about it. Like right now, at this very moment, who would you give your wallet to?
Yeah.
And then with the fiduciary, because they're legally bound and there's laws for any fiduciary, you can always take them to court. There's always a recourse. A lot of people don't realize that, but fiduciaries, if they're not doing what they're legally bound to do, you could take them to court and they can be removed.
Okay. Okay. All right. And then we talked, you said, medical directives. So I have medical directives. I've had medical directives since I was 21.
Okay.
I got pregnant with my son and life was looking like it wasn't going to last. Because I coded a couple of times while I was pregnant with my son. Yeah. So I needed to have medical directives to say what was going to happen in the event that I, did pass on. So I've had medical directives for many, many years. Tell us, I know what medical directives are and I know what they do, but tell the audience what, why you need it and why everyone should really have medical directives.
Okay, well, exactly for that reason. You want to have this in advance in case there's a medical issue or medical circumstance where you need someone to make a medical decision on your behalf. When you go into a hospital situation, of course, a lot of times the hospital will make you do it. Even if you don't have one, they start to shove a piece of paper right under your nose as they're wheeling you in and they're saying, sign this, sign this, sign this. And that's, again, when you don't want to do it. You want to make sure you do it in advance and have it as part of your estate plan. So you have that document in place. But so many people do come to me when they're going in for surgeries. And it may not be major surgeries. I have some people who came to me when they were having leg surgery. Other people. Yeah, other people when they're just having an elective ambulatory surgery, in and out surgery, just in case, because while you're under, someone still may have to make a decision and they need to know who to speak to. Or even as you're recovering, even if it's an elective, in and out surgery, as you're recovering, who should they speak to?
Right, exactly.
But I'm so glad you made the point about pregnant women, because I'm saying this right now with COVID. Right now, I have a niece who's only in her 20s. Nothing's wrong with her. She's healthy. And I was just telling her last week, we have to do a power of attorney for you before you go in. Her baby's due in July. And hopefully this COVID crisis will be lifted. But, they're not letting people in the hospital, just one person, and sometimes no one but that person. So you definitely have to have someone that the hospital can call on if anything should happen.
Right. Exactly. And for me, I knew I needed to have a medical directors because sometimes your parents are not the right person to make the decisions for you because they're making the decisions based on emotions and not logic. So
Right.
my mom was already telling me, if it came down to your life or my son's life at the time, she was like, I know you. I brought you here, so I'm going to choose you all day, every day. And those were decisions I didn't want her to have to make. So I didn't put her as my power of attorney. I put someone else who could
And
just
that's
make
what
that
parents
logical
always say.
decision. Huh?
That's what parents always say.
Exactly.
You all day long
Uh-huh.
because you're here. We
Right.
all
Exactly.
know and love you. But you make another great point. Tracy,
Mhm.
you're making some really good points. You could be
Thank you.
doing
I've been listening. I've been listening.
Um, great point. You want to put someone in place. Again, when you're thinking about the power of attorney, you want to do it in advance. And I always say, think about somebody who makes great financial decisions, sound financial decisions, someone who's very trustworthy. And when you're thinking about a medical directive, of course, they have to be trustworthy because they're also a fiduciary. But you want to make sure that that person makes sound decisions, period. That they think with their mind, not necessarily with their heart, that they can make tough decisions if they have to, that they can stick by their decisions. And if there's a room full of people disagreeing or fighting, they can still cut through all of that and stand strong and make the decisions that are necessary. And that's very, very, very important. Your power of attorney person may not be the same person you put in place for your medical directive. And you make the great point that it doesn't even have to be your parents.
Right.
It can be a friend, it can be a cousin, it could be a best friend, it can be a god sister, it could be whomever you trust. I recommend in those situations that it's somebody who can get to you quick enough. But some people may not have, their children may be in other states. So if that's the case, I mean, that's fine if that's what you have to do. But if to the extent you can, hopefully it's someone in proximity to where you are who can get there quick enough if need be.
Okay. Okay, so a lot of people like to say today that a will is antiquated, that no one should be doing wills anymore. What exactly is a will, and who needs a will, and when do you need this will?
Okay. And just to speak to the antiquated part of it, wills are still around and they're still going to be around.
Right.
It's always the new flavor, like, is it, this kind of tea, kombucha, I guess you call it, or are we going with pomegranates, or are we going with chai, are we going with, wills will always be around. And it's always the debate of a will versus a trust, a will versus a trust, a will versus a trust. Both of them are good. It's better to have something in place than nothing. That's the point. You need to have something in place than nothing. And while people are busy debating a will or a trust, they don't have anything in place. So the will is a document. It has to be a written document, written and signed and witnessed by two people. And in that document, it states exactly who you want to leave your assets to. And the benefit of a will is you don't have people fighting. You want to leave a legacy, not a headache. You want to leave order, not confusion and chaos. And if you have multiple children, or if you're in a blended family where you raised your husband's children, he's raised your children, now everyone's adult, and only your blood children can inherit, not the children you raised from your spouse. So that's part of it too. If you want to leave anything to the other children that you may have raised since they were 2 or baby, they would never inherit from you unless you put something in a will. Or if you want to leave things to your nieces and nephews, for example, like me, I don't have children and I have nieces. I may want to skip over my parents because my parents are elderly, and I may want to skip over my siblings, and I may want to leave everything or the large chunk of things to my nieces to help them as they get older and they may go to college or whatever the case may be. Or I may leave smaller percentages to my parents and my siblings, and leave, like, let's say 80% of my estate to the nieces and nephews and 10% to my siblings and 10% to my parents. But either way, you can't make those decisions unless you have a will.
Okay.
Because the law, otherwise, when you don't have anything, the law of the state governs. And the law of the state is not going to say, oh, 10% here and 10% there and 30% to this person and 25% to that person and 15. It doesn't work like that. Okay. It's going to go to one layer and then the next layer and then the next layer. And suppose you want to leave things to charity. That's not going to happen with the statute.
Right.
Or if you want to leave something to your church or to your sorority or to your fraternity, that's not going to happen. Or let's say, a lot of people don't think about this, legacy building, right? Let's say you want to create a scholarship fund. People think you have to have so much to do an estate plan. Most of us have a house, and a house is our biggest asset, right? So if you have a house that's worth 300,000, 400,000, 500,000, and in New York, you know, houses are worth north of that. And let's say you have half the equity, $600,000 house, you have $300,000 in equity, and you may owe, you know, the balance on that. Anyway, when you sell it, you make $300,000.
Right.
$300,000 is a lot of money that you can do something with. You can put $100,000 or $50,000, whatever amount you want, into a scholarship fund. I've done that with so many of my clients. And the scholarship fund can be for your own family. One lady, she put it for her nieces and nephews, and then for generations to come. And almost like a family reunion committee, she created a committee of her cousins who would determine who would get the scholarship each year. And it would be a certain amount for the child to go to college or for books. And here she is leaving $5,000 and $10,000 scholarships for how many more years to come.
Oh, that's nice.
That's a legacy.
Nice.
I've done so many creative things. I had another client who didn't have any children, and she did a lot of missions work at her church. She left her home, which was in close proximity to her church, to the church for missions work.
Okay.
For people who were doing missions work and had to have some place to stay. How great is that? I had another lady, she had a vehicle, a minivan. And you would think, right, minivan, it's not a Porsche, it's not, you know, but this is how people think. And that's what I'm trying to say. You have to bunk all those myths. This lady had a minivan. And in her will, she said she wanted to leave her minivan to another single mother with 2 children.
Oh, wow.
How great is that? There's
wow.
So many
I never thought about stuff like that.
So many things you don't think about.
Right.
And I've been doing this since 2002, 18 years. So many things I would think about. And we talk about it. I have, you know, free consultation. I sit with the person for about 45 minutes to an hour, go through my checklist. And as I talk and as people talk, you get more creative.
Right.
And it doesn't have to be a lot.
All of her information is in the description above. So her phone number, her email address, and her website. So make sure you reach out. Go ahead.
Yeah. And my website is ebrownlegal.com. I didn't use my name because people don't know Eilene, right? So I don't use that causes confusion. But yeah, there's so many cool things. And that's why I also say that people should go see an attorney. Most attorneys have free consultations for things like this.
Right.
And even if they don't, the consultation fee is usually nominal because we want to get people in and get them the opportunity for a consultation.
Right. So with a will too, one of the things that the will does, it prevents your estate from going into probate, correct?
See, that's the debate between trust and wills. That's the constant debate. With the will, it has to be probated. With the trust, there's no probate.
Okay.
And that's the thing that people latch onto. That's why people want to trust, because they think, oh, I don't want to go into probate. It's going to cost me so much money. However, I put on a piece of paper for a client just about a week ago. Let's put the cost down. It depends on how much you have. You know, if you have Donald Trump and Oprah Winfrey money, you want to trust. And they're really doing a lot of trust planning too. They're probably even giving things away as people are alive and all of that kind of thing. But if you have, let's say, a house, a car, and a bank account,
Mm-hmm.
When you think about the house and probating the house, the probate fees are not that high necessarily, depending on what state you're in. And I could talk about here in Maryland. The probate fees are not that high. So let's just say hypothetically, the probate fee is a certain percentage of the value of the estate. So let's say hypothetically, the probate fee is $200 or $250. When you do a trust, you're going to spend thousands to do a trust. Okay. So I tell people it's just which end are you going to pay the money on? You're going to either pay the money up front when you do the trust to the lawyer, or it's going to be paid on the back end when people have to probate your estate to the lawyer, or maybe you don't even have a lawyer when you probate. Okay. But you're paying that fee just in which direction.
Okay. And I think in one of our conversations, and I hope I'm getting this right, when we were talking about wills versus trust, one of the things that you said, I think you said to me, is that you still need a will if you have minor kids, even if you have a trust. Was I correct? No. Yeah.
You still want a will if you have minor children. And even with the trust, you have something called a pour over will. So you're going to have a will in place because it has to say everything that I have is going to pour over into this trust in case I didn't list everything in the trust. Because part of a trust that people don't do correctly, because I've done this work, I do it on the front end and the back end. I do probate work as well. So I get to see what happens. And that's great because when you've seen the end, so to speak, you know how to do it better in the beginning. Right. So I've even had clients where I've done their will and I then had to probate the estate. And of course, even people where I haven't done the will, I've had to probate the estate. And then I've also been appointed by the court as administrator of the estate when heirs can't qualify. If they have, they don't have the finances or they're arguing, they appoint a neutral party. But the thing about a trust is so many people forget you have to fund the trust. You can create a trust all day long, but if you don't fund it, it doesn't matter. So I give the example with the trust. Think about a chest, like those trunks people used to take to college when they fill it. So think about a chest like that. If you have your house, you have your car, everything needs to go in the chest. You can't keep everything sitting on the floor outside of the chest. It has to go in the chest, and the chest is the trust. So if you haven't placed everything in that trust and funded it, that's what funding it means, then it doesn't matter that you have the trust because everything's sitting outside of the trust. You're going to have to probate anyway. Okay. And I've had situations where people never funded the trust and we had to do probate anyway. So here they are, they pay for this trust, and a lot of people don't even know how to administer the trust. Like they have no clue on what they're doing with the trust. They go get this trust, they never fund it, and you're still going through probate. And it's still, and in this instance now, you haven't even made any plans for the assets. Right. So now we're in probate as if you have no trust, no will, which is intestate, and everybody's fighting, and that was never your intent.
Right. Okay. So the trust is basically an entity, correct?
Yes.
Okay. And so tell us about that. So it's basically like a business entity that you create to put your, like you said, to fund, to put all your assets into, to protect your assets from lawsuits, especially if you're in certain types of industries as well, correct?
Well, I don't really want to talk about it generally like that.
Okay.
I often think, because it's not black and white. Okay. And so many people come to me and they say, "Oh, I want to, I don't want creditors to touch my assets," and that's so much deeper than just a basic. Gotcha. Yeah. Okay. So to people, if people are curious about that, they should really go see an attorney. That's when you're getting into, and you really want to go see a specialist too.
Right, because I've heard horror stories about people going to lawyers who did not specialize in estate planning, and they just they paid a lot of money and totally screwed up their trust. So, and they had to have it done all over again. So it's like what I always say, go to the people who know what they're doing, because when you do it, when you make an amateur error, it ends up costing you twice or 3 times as much.
It does. Yeah. And it's the same thing with the will. A lot of people think that wills are no big deal. Right. So a lot of attorneys every attorney or a lot of attorneys think they could just do a will. It's a basic will. I could do a will for my mom, my sisters, my friends, whoever come to me. I'll just do a basic will for you. But that's not true, because I have currently seen a will that is not, and it was done by an attorney. I thought it was done by the decedent. It's very sparse. And you can tell when people don't practice in this area because they don't fill it out. They don't, it's no point in having a will that's just so black and white, because now you're trying to figure out what were you leaving to who when you made all these big, broad, general statements. And now we don't know what you were trying to do and leave to who. So the court will probably have to decide some of it, because it's just these big, broad, sweeping statements. And then one paragraph talks about three things when maybe each paragraph should have been separate. And then you go to the fourth paragraph and it goes back to the second paragraph, but you already talked about that in the second paragraph. So now we don't know, were you leaving this to all of your children or just the daughter, as you mentioned in the other paragraph? So people who don't practice in this area think it's a very simple area to practice in, and they simplify it, and it really is not. Every area, I talk about lawyers like doctors. Doctors specialize. You have somebody who deals with the eyes, the nose, your hands, your feet. You have orthos, neuros, cardiologists. Same thing with law. You're not going to go to an orthopedist to fix your heart. And just like, you shouldn't be going to a criminal attorney unless they do estate planning law to do a will. And you shouldn't be coming to me to do your criminal case. And I'm not going to do it. And because I don't do criminal law. But it's the same thing. People have to think about it that way. And while I'm on that subject, people shouldn't be trying to do their own legal documents either. I know we have LegalZoom and all these other things, but I often say to people, and people actually come to me and say, well, can you review my document that I did? Legally, I can't. No, ethically, I can't. We have ethics, a code of ethics when we get sworn in. But I often say to people, you're not going to operate on your own foot, are you? So why are you trying to do certain legal documents? We went to school for 3 years. We had to pass a bar exam that many lawyers don't pass when they've gone to law school. So we have a practice area, even though you have all this stuff on the internet, everybody thinks they could be a kitchen table lawyer, and you shouldn't do that. Just like you shouldn't be a kitchen table doctor, Googling everything and thinking that you have all these diseases that you don't have.
A Google MD.
Right. You shouldn't do it. And at some point, I bet you go to the doctor, don't you? Kitchen table. And it's the same thing with the lawyer. And because these documents are voluntary, so to speak, a lot of people put them off. A lot of people procrastinate. A lot of people delay, and they think, oh, I don't really need that. Or I'll wait. I'll wait. And there's no better time than the present. You never know when things are going to happen to you. Incapacity doesn't give a warning sign sometimes. Incapacity can sneak up on you, just like dementia. I have a lot of people bring their parents in and grandparents in, and they want to do these documents. And it's too late because their parents or grandparents may have dementia. And you have to be of sound mind and body to do these documents. So when you need them, you need them. I always say when you need them, and it's too late. So you want to do it before then. You want to plan in advance. And Tracy, can I just go back to one thing you mentioned? And I don't think I answered this when you talked about a will when you have young children. You definitely want to have a will when you have young children, because you can put guardianship in place. And that's so many people don't think about too. You want to put a guardian in place for your minor children so that you can have a say as to who should raise your children. You want to make sure that you have a say on who should do that. And it's taken strongly into account when the parent does that in a will document.
Great. All right, that was going to be my question. So if you don't leave guardianship in your will and you have young children, then it's up to the court really to decide who gets the child. So if there's not a father or mother or grandparent that the child can go to, then the child ends up in foster care, or may still end up in foster care until, if there's some disparity about who should have the child, until the courts make a decision, correct?
And it's two things you're saying there. And I've done family law as well.
Mm-hmm.
So I'm speaking from that perspective. If I had never done family law, I probably couldn't really answer this question because, again, remember we talked about the doctor and all the different areas. So two things that you mentioned. One is, if there's no one there, the child may not end up in foster care because people can petition. Someone can petition for custody of your child. You may have a best friend or their godparent. So they can always petition for custody of the child. But on the flip side, the second thing I want to mention is that godparent would never get custody of the child over family members, let's say, because again, there's a statute of priority of people. And you may want the godparent, or you may want your cousin, you know, who's like a sister to you, who lived in the house with you, who your son was always around, you know, and who is similar to you to raise your son, who may also have a son your son's age, you know, so you may have a lot of reasons, who knows the school and knows the community, and she won't move out because you've left your house to her. So your son can stay in his home and stay in his room and stay with familiar things after experiencing a tragedy such as losing his mother. So you already know all of that. But if you don't put all of that in place and you pass away and you have parents and you have siblings who all may want custody of your son, even though you know you wanted your god sister to have custody of your son and you all talked about it and you had a reason for it, that would never happen.
Okay.
That would never happen. Well, never say never, but I mean, she has to,
go
through layers and petition, and your parents still would probably win to some extent, or your siblings, because they still have priority over her. Because if they're equal across the board, as far as the court is going to see, like the court is not going to know all the intimate details of you and your god sister. You know, they're going to see people who are financially sound with the education. Everybody has a home. So they probably won't go to the god sister. They'll probably go to those 3, 4, 5 other people that come before her.
Okay. All right. So if people wanted to make a decision between will and trust, that would take a full-on consultation to decide which one is best for them, correct?
Absolutely.
Okay.
That would take a full-on consultation. And I have to be honest with you, just as many people do a will as do a trust.
Oh, really?
So many people decide, absolutely. So many people decide they want to do a last will and testament, and that they don't need to have the trust, and they don't want to fund the trust, because all of your assets have to be placed in the name of the trust. You have to change over your deeds and your bank accounts and all of that.
That's what I thought. I was just talking to someone about that the other day who has a trust. And I was like, so when you bought your car, didn't you have to buy it in the name of the trust? Or, you know, something else, that they were buying a house. And I was like, did you have to buy it in the name of the trust? And they were like, no, there's a line in my trust that says anything that I own automatically goes into the trust. So I was like, okay, maybe I'm understanding it wrong.
And it all depends. That's why I'm saying there's no black and white.
Right.
You know what their trust document says.
Okay.
And some trust documents may not say that. And you don't really know. And sometimes they don't even know what happened at the closing table, because sometimes I look at people's deeds and they think it says one thing and it doesn't.
Oh, wow.
So, you know, everybody's situation is different. I don't think there's any black and white situation, but the key is that you want to make sure that you're funding the trust and that your assets are legally being placed in the trust.
Okay, great. All right. So we didn't even get to talk about your backstory, because I was so enthralled with getting this particular information out about, you know, trust versus will and why we need it, because I want people to stop having to scramble when someone passes away to try to get things together. It just seems like absolute chaos. No one has the money to pay for their family. And I mean, you can't grieve until the body is in the ground. That's when the
That's
true
right.
grieving process starts. It's after the funeral, you know, or the cremation. But once you are chaotically trying to get the arrangements together, figure out how you're going to pay for it, who's getting what, and then the families start, you know, arguing and, oh no, mom wanted me to have this, and you know, whatever, whoever the family member
And
is.
you
It
and
becomes
you
crazy.
see when you said, "Oh no, mom wanted me to have this," people arguing over small things.
Yes.
A
Yeah.
lot of times, it's not a lot of money
Mhm.
involved.
Right.
A lot of times, and people will fight. I've been doing this for 18 years. I've done
Mhm.
it, like I said, for the court system. They appoint me. I've been, I've been the attorney on the end for people. People
Mhm.
will fight over small amounts of
Yes.
money. And
Yes.
I find the smaller the amount, the more fights there are, because people with assets have usually spoken to their children, and
Right.
their children usually have assets. They have their own
Right.
homes, and they have their college degrees, they have children, they have spouses. They're not fighting.
Yeah.
I have a client right now who has so many assets and
Mhm.
everything's in order. I mean, so perfectly in order, everything, no debt on the house, and multiple vehicles that have value, and new vehicles and bank accounts and life insurance in place, and everything like a textbook.
Yeah.
None of those children are fighting. They
Well,
all
I
have
guess I'm so
great,
grateful for my
yeah, they have
mom
great,
that
great
when
careers.
yeah, when my mom passed away, there was no fighting amongst us. Like you said, we all had degrees, we all had our own assets,
That's right.
right? And her assets were meticulously done by a lawyer. So everybody knew what they were getting, when they were getting it, and there was
Right.
just nothing for us to fight or argue over.
Exactly.
There was four of us, the insurance split up amongst the four of us, we all got our checks, and life went on. There was no arguing, there was no fighting, there was nothing. And I am so grateful that my mom had the foresight to set up her stuff correctly, because I just couldn't imagine, you know, arguing and fighting with my siblings over
Right.
some
And
dollars and some
families
property.
break up over it. And it's
Right.
usually factions. There'll be, two or three on this end and one on the other side, or two and two. I've seen it so many times. It is so sad, and it's not what the parent would want. And that's why I often say that parents know their children. And
Right.
that's why you want to have a will. Parents know their children. You don't want the court saying what should happen.
Hmm.
You may be leaving the house to all of your children,
Hmm.
or you may leave the house to three of your children
Hmm.
and leave a bank account to one.
Right.
Maybe because the three can make a decision on the house, and the
Hmm.
one, but it's equal amounts of money. So parents really know what they want to do. And one thing I didn't mention about the trust versus the will
Hmm.
is, in a trust, when you have minor children, you can say what will happen with the assets. They don't have to inherit right away.
Right. Oh, that's
So
good.
here in Maryland, they inherit at the age of 18.
Hmm.
So a lot of people don't want their 18-year-old getting six figures.
Right.
So in a trust, you can say what's going to happen. But I also do, some people don't know about this, there's testamentary trust. So I
I've
put a
never heard
trust
that
into
one
the
before.
will. A lot of people don't know that. And
Uh-huh.
a lot of attorneys probably don't do it, especially
Okay.
attorneys who don't practice in this area.
Hmm.
But I do it routinely for clients, because that's what people really are concerned about. They don't want their 18-year-old
Right.
inheriting. So
Hmm.
I do, you can say they'll get, 1/3 at 22, because
Hmm.
usually that's when you're graduating college.
Right.
Other third at 25, because maybe they're going to go to grad school. And
Hmm.
some people even go out to age 30, like another third at age 30. Most of my clients do 22 and 25.
Hmm.
But I've even seen people go out to age 30, because then they feel like they may be getting their first condo or first,
Right.
place, and they'll have a nice little nest egg to do that with. But, like I said, parents know their children, but you
Right.
can do all kinds of creative things. That's what I love about estate planning. I love sitting with the client. I just let them talk. I
Uh-huh.
let them download, because I'm processing, because I know so many creative things, and we start talking and they start getting excited, and
Mhm.
then, things work out.
That's awesome. And I think I had asked you before, but just make sure that I'm saying it correctly. You can put your life insurance in your trust or your will.
You can. You would have to name your life insurance as the beneficiary of that. Because
Okay.
ordinarily, the benefit of life insurance ordinarily is that it passes outside of probate. So you
Right.
can put names on the policy, and they automatically get that money. They would just need a certified death record. And that's really the benefit of it. But if you have minor children, that may be a little different. But like your mom with you all were probably adults when she passed. And like you said, you got your check right away. And that's the beauty of life insurance. Like that's the quickest money that anybody's going to usually get.
Right. And what was even better about that too is that we didn't have to come out of pocket for the funeral itself. The repast, yes, but the funeral, the life insurance paid the funeral home directly. So that was an expense that we did not have to attain or even think about. It just made the whole process so much more simple, right? And we were able to go from her dying to the funeral in 8 days.
Exactly. When there's life insurance in place, same with my dad, because we had life insurance, and when the funeral home knows you have life insurance, they don't pressure you to take any money out of your pocket.
Right.
It's so much smoother, and things work out much better that way.
Yeah, the life insurance paid the funeral home, and then the balance that was left over was split between the 4 siblings, and that was it.
Right from everybody's check came right from the life insurance company.
Yes,
which is beautiful too. Nobody has to fight. Everybody gets their check directly from the funeral. Yeah.
So I thought that was wonderful, and I'm a big proponent for estate planning and getting some life insurance. I think it's irresponsible as a parent, especially as a person, period, but especially if you're a parent, it is irresponsible not to have a life insurance, at least enough money to bury you, right? If nothing else.
I agree.
It is not, if you do have assets, I think it's irresponsible for you not to allocate those assets to whomever you want to allocate them to, instead of leaving confusion behind, people fighting and arguing and never talking to each other again for life because they're mad. They're mad that
over things. And I even, because I do probate work, I always tell people when they're fussing and they're fighting or they're rushing, when is this going to be over? This is not your money. This is a gift. You didn't earn this money and you didn't save it for this money. This is all a gift. So I'm not sure why you're fighting or what you're rushing. And people need to keep that in mind. This is not your money. It's all a gift. It's more than you had before you started, and you did not earn it.
And then based on my knowledge, I know that probate can be different in different states. So I know some states probate can last up to like 7 years, so it can take some time for you to get things settled. So
it can, but this is the other thing. And this is one of my pet peeves. People try to do things themselves, right? They don't want to hire a lawyer. That's the only reason anything should take 7 years. Because when I get involved, you all can fuss and fight all you want. I have a legal obligation. I know what I'm doing. That the estate can close in 6 months here in Maryland because it's a creditor period where it has to stay open for 6 months so creditors can make a claim. As soon as that 6-month period is done, I'm ready to close out the estate. Because I'm not playing around. I'm not getting into the fight with the ring with you all. I'm here as the neutral party with the knowledge to get this thing moving. Again, attorneys who don't do this work, they let the fighting go on. They let the confusion go on. They don't even really know how to keep the thing moving along. I keep it moving along. My estates are closing in 6 months.
So it's the DIYers and the attorneys who are not knowledgeable in this area that prolongs the probate process. Well, there must be a lot of DIYers, because I'm always hearing the horror stories of years and years and years of probate.
When I hear that, I say, first of all, most likely you didn't go to an attorney. You went in year 6. Or you have an attorney who does not practice the state law. And the other thing is, every attorney, every doctor, I often say, when you're picking an attorney, think about a hairstylist. When you go to a hairstylist, everybody tries to go to somebody they can relate to, right? That's how people pick their hairstylists. There's a bunch of hairstylists out there, but everybody picks the one that they can relate to, that's comfortable for them, their temperament, and what they're looking for. Lawyers are the same. It's no different. We're all different people.
Right.
So you want to go to a lawyer who's organized,
Mm-hmm.
who keeps things moving, who's responsive, because you may have a lawyer who's not returning your phone calls. So maybe that's why it's taking a long time.
Yeah.
Or a lawyer who has so many cases, they're not organized and they don't keep on top of the cases. So that's why it's taking so long. Or a lawyer, like I saw a lawyer once in a case I was appointed in. He was a Caucasian man and he had 3 Black female clients who lived in New York, and this was a Maryland probate. So he was not accustomed to the New York temperament. I was. These young ladies,
you're in New York,
they were in the street. They were in the street with the real estate agent. This is their aunt's house, but she had assets, right? They were in the street like ready to fight each other. The man was so nervous. He was standing behind the real estate agent, who was also an African-American woman. We looked at each other. I let them go on and on and on. And I said, let's open the store and go in here, and because you have to inventory the assets. So it's their first time all together going in the house to see what was there. And they saw various things and they want to fight. They want to touch it. They want to keep it. You all need to put it all down because we have to inventory it. And it has to be inventoried, and there has to be a list that goes to the court before anybody can take anything. And I just say it that calm, right? It's the law. So everybody looks at me. They put it down. The gentleman was so scared, but again, it's your experience. You have to have experience doing these things. You have to know how to keep it moving along. That case could have lasted 7 years. They want to file stuff constantly. Why are we filing anything? Doesn't make any sense. You want to argue. You want this. They wanted money in advance. They wanted a piece of their inheritance, a piece. Okay, I did that the first time. Once they figure out you can do that, no, we're not going back. We're not petitioning the court anymore. We need to get this done. But it's that kind of thing. You have to have the right personality to keep it moving.
Okay. Got you. That makes perfect sense. And I do have to have you back on because, like I said, we didn't even get to your entrepreneurial story, but this was essential information that I think our community needs to make to get, especially right now with COVID-19 and so many people passing away, which is absolutely sad. I really want people to understand what it is to have an estate plan and who you need to go to, that you need to not do a DIY estate plan. You actually need to go to someone who is knowledgeable, a lawyer who is knowledgeable in that area, so that you can get it done and get it done right. Because that is the only way that we're going to build generational wealth. Exactly. That is the only way that we're going to build legacies, is to have a plan in place that allocates what we have to the people who we want to have it for generations to come.
Right. And a lot of people right now are asking me, how can I get a basic will done? I think you should just get a consultation with the lawyer. And I think everybody
this is her website, so you can go over there and book yourself a consultation. It is free of charge. Am I correct?
Yes.
Yeah. So you can get a free consultation. So go on over and book a consultation today. I am begging you guys to please get your lives in check. Put some checks and balances on the things that you have. You worked hard for the things that you have surmounted in your life. You do not want to leave confusion behind. You don't want the state to come in and make decisions on your behalf. Make your own decisions now. I know it's hard to think about death, but the fact is that we all have to go at some point in time. And it may not be COVID-19 that takes us out, but every night I go to sleep, I don't know if I'm getting up in the morning. I just don't know. Right. Yep. And I have children, and I have one minor child and one adult child. And I don't want that I go to sleep tonight and I don't wake up and my kids are left in peril, just wondering like, okay, what's going on? You know, where are the assets? What has mom left behind? Because they have no idea where anything is. And a good estate plan can have all those documents, everything. The lawyer will know where all of your assets are, so that your kids can seamlessly go through the process of putting you to rest, and they can go on with the grieving and healing process in the end.
That's right. You're absolutely right. It's so important to do it, even when COVID's not in place, because none of us know the day or the hour.
Right.
We all know that we're all going to pass away, and you never know when. So it's better to be prepared. I mean, I have a will. I've had my will, since I was a young person. And it's really important to have a will, I think, when you don't have children.
Mhm.
And for professional women out there, most of us have assets.
Yes.
And you want to make sure that you are saying what you want to happen to the assets.
Mhm.
And also, Tracy, people can give me a call if they want. My number is 301.
Wait, let me put it down. Give me
Okay.
1 minute. Okay.
A lot of people like to, in this area, they like to talk to you. They like to make a phone call.
301.
301 352 8960. Or they can email me at ebrown@ebrownlegal.com. But most people, I find, believe it or not, they call me.
Okay.
Like
Right.
to
So
talk.
you can call, you
They're
can email, you can go to the website, but you need to reach out and you need to get some consultation on estate planning. It is for everyone. It doesn't matter if you only got $2 in your account. You still need a will or trust, whichever. You need some type of legal document that says what you want done to your body when you pass away. Some people want to be cremated, like myself. I
That's
don't
right.
want to be buried. Please do not bury me. And my kids know this, but it's also in that legal document that I do not want to be buried. I want to be cremated. You
That's
need to
right.
let people know what you want for yourself, even after you're gone. You can make those decisions. Like when my grandmother died, my grandmother knew she had cancer. She knew she was going to pass away. She bought her plot. She knew she wanted to be buried on top of the hill in New York, right? So she
Mhm.
bought her plot. She paid for it. So nobody had to come out. She paid for her entire funeral before she passed away. Everything was set, the repast, everything that she wanted for her going off ceremony was done prior to her death. We need to stop being afraid of death because it
Right.
is coming to each and every one of us. Okay.
Right.
I don't want to be on my soapbox today, but I need you guys to understand it is coming whether we want it to or not.
That's
We
right.
just don't know the time, the date, the hour, but it's coming to us all, and we need to prepare. Stop leaving chaos behind. It's not a good look for you. It tarnishes your legacy that you took all of your life building because you left chaos behind, and your family members are more going to remember that the legacy, the chaos you left behind, versus all the great things you did.
Right.
Yeah.
And as parents, that's not what you want to do. You don't want to know, or you don't want to think that your family is going to be broken up when something happens to you over things. I mean, parents work their whole lives to raise their children to love each other and to bond. So you don't want them to be broken up at the end when they really need each other to support each other.
Yeah. So I know, guys, that this is a heavy topic for 6 o'clock in the morning, but it's a necessary topic, and it gives you something to think about all day today. And hopefully, you pick up the phone, you call Eilene today, or you go to her website and you book a consultation. It is free to talk to her initially, so she can, kind of get a gist. If she's not licensed in your state, she has a wide network of lawyers that she's affiliated with that she can refer you to in your particular state. And trust me, if she's referring you to someone, it is someone who is extremely knowledgeable in that particular area. Because like she said, if you're DIYing it or you're using a lawyer who is not an expert in estate planning, that is when it takes 7 years for probate. Okay. And we don't want that. We want things to be settled as quickly as possible so people can move on with their lives. So,
Absolutely.
yeah, Eilene, I keep calling you Eilene. Eilene. Eilene.
So many people do that.
Yeah. Eilene, could you give us like some tips, just some last words that you want people to take away from this talk that we had today, which was longer than usual because it's usually half an hour. We're almost here an hour, but like I said, needed information.
Yeah, a few tips. Number one, don't delay. You need to do these documents while you're of sound mind and body. When you need them, and it's usually too late. Number two, bring your parents and your grandparents in sooner rather than later. If you see that they're starting to have dementia, don't wait. Because once the dementia sets in, if they're not of sound mind and body, they probably won't be able to do a will or a power of attorney or medical directive. And most people are trying to get them to do a power of attorney so you can help handle their finances, because so many of us help auntie and grandma with their finances and their banking. So you want to get those documents in place beforehand. And number 3, don't think it's too expensive or it's going to take too much. Call an attorney, get a consultation, even if it's not me. Call an attorney. You want to get a consultation and you want to go in, because a lot of people say, I need to get myself together. I need to get things together. It's the same thing, when you're trying to exercise or you're trying to lose weight. If you could get it together, you would have already done it. You need to just walk into the gym or walk into Weight Watchers, walk into the attorney's office and start to talk, have a consultation. And it's easier than you think, because the attorney has seen so many circumstances and they can walk you right through it in a matter of 30, 45 minutes. And you've been waiting years to do it. And you can walk out of the consultation with a clear mind and with a clear plan.
Awesome. Great. Thank you so much for being my guest today. I hope that everyone that was listening got some pertinent information and will move forward in making the necessary decisions to get their affairs in order. So thank you for joining me for Morning Tea, and I will see you.
Thank you for having me.
You're welcome. And I'll see everyone tomorrow. Bye. Again, Eileene's Eileene's website is ebrownlegal.com, and her phone number is 301-352-8960. Please give her a call, make an appointment today. Bye, everyone.
Bye, Tracy.
Bye.